case briefs, and so much more. LSData's got what you're looking for.
In Re-On-Site Sourcing, Inc., a 2009 United States bankruptcy court case in Virginia focused on ensuring that a Chapter 11 plan paid administrative and priority claims in full before addressing general unsecured claims. On-Site Sourcing, Inc. filed for bankruptcy under Chapter 11, and on the first day, sought approval for a $28 million sale of its assets to Integreon Discovery Solutions, DC, Inc., under Section 363 of the Bankruptcy Code. The court had to assess whether such a sale could replace a Chapter 11 plan and took into consideration the debtor's pre-petition sales efforts, debt structure, and post-petition financing. Integreon was the lone pre-petition secured creditor, and the Unsecured Creditors Committee supported the sale with modified terms. However, the proposal excluded provisions for a general unsecured creditors trust and releases for 3 employees. To avoid evading the Chapter 11 plan confirmation process, the court approved the sale of the debtor's assets to Integreon, while excluding provisions that would serve as a substitute for a Chapter 11 plan. This decision was based on the compromised fiduciary duties of the debtor, which demanded the removal of certain provisions.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.